Hello and welcome to today's edition of the myHR Minute webinar. We would like to thank you all for attending and for your continued interest in our webinars. Before we get started, I wanted to remind you all that this webinar is being recorded. We will follow up with an email tomorrow that will include the slides, the recording, as well as the HRCI or SHRM recertification credit. Additionally, if you have any questions, please open up a ticket in our Ask an Attorney portal so that we can provide you with a specific legally backed answer. If you're not a client of ours and would like to learn more about our subscription services, please email us at info@myHRcounsel.com. We hope that you can join us for our upcoming webinars. On August 9th, we'll cover I-9 compliance, and please join us to learn about the new Form I-9 and requirements. On August 15th, we team up with Alliance HCM, and we'll be covering mastering compliance and hiring new employees. On August 16th, we'll cover overtime and calculating the rate of pay, and on August 23rd, wage deductions. You can now take our webinars on the go with our HR Express podcast. We will release the recordings of our webinar in podcast form each Thursday, as well as additional episodes. You can find our podcast on Spotify as well as Apple Podcasts. And now I'd like to welcome Britt Waterman, a senior attorney at myHRcounsel.
Thanks, Dan. Welcome to everyone joining us today. I'm so happy that we're able to make it to our discussion on social media in the workplace, talking about employer rights and employee rights and best practices dealing with social media in the workplace. So the social media starts with pre-employment use of social media. And when I say pre-employment, this is not just pre-employment. This is kind of, if the person is already employed, this would be pre-promotion, pre-transfer, deciding when and how often to schedule, checking up on someone who said they were sick to see if they were really sick. This is anytime you would use social media because you think it will tell you something useful about an employee that you could not necessarily get just by bluntly asking the employee. So an employee may not be lying about their work history or education. They may just not have updated their social media posts. Posts can be taken out of context. They can be separated from other relevant information. There may be many people who have the same name as your employee. You may not have other information to filter. You could have posts about partying from someone who is now in recovery, which raises issues under the Americans with Disabilities Act. The internet is forever, and someone may have a friend or a family member as a friend or a follower because they love that person, not because they necessarily endorse that person's offensive views. Seeing someone's high school class could show you their age. People put their religious affiliation on their profile, familial or relationship status, sexual orientation. Then when you take any employment action from hiring that person or refusing to hire that person to making the schedule, you could be subject to a discrimination claim because now you have that information about that person and you're making an employment decision. And anyone can tag someone on Instagram or Twitter. A relative that the employee is not close to could use the employee's wedding hashtag to make a racist post. Some illegal scam account could be retweeting the employee's tweets, making it look like the employee is involved. And we all know about catfishing, things like that. So pre-employment use of social media is so prone to pitfalls that it's really ill-advised to use this as a tool to screen applicants for employment. Communicating with employees on social media. So there could be a religious reason for someone not being on social media. Someone could not have a smartphone or internet access. They could be a domestic violence victim. And being a domestic violence victim is a protected class in some states. Do not make any comments or insinuation about age, about someone not having a social media platform or a smartphone because of their age, or saying that Facebook is for boomers and TikTok is for Gen Z. Age is a protected class, and anything about age is better left unsaid. Don't point out that someone is old school and doesn't use computers. If you end up terminating that person and replacing that person with a younger employee, that's just going to be fodder for a discrimination suit. That's going to be much easier for you to lose. People, if you're setting up your own employer page, again, people have protected class reasons for not wanting to participate in it. If you use the page to promote your employees or have a sales contest, something, like that, and you have someone who doesn't want to be on social media for protected class reasons, they're potentially losing out on a benefit, and that has a disparate impact, which would be illegal. Um, Things like GoFundMe's for illness or injury should be kept off of work group, even if your employment work group, Facebook group is set to private and the company is small and the employee doesn't care if somebody sees their medical information, for example. Nothing is truly private, especially Facebook. And if you've got a GoFundMe for illness or injury and it gets out to a third party, you will have failed in your responsibility to safeguard that employee's confidential medical information, and that's going to have problems for you. So people will also say online things that they will not say to people's faces. You have to protect your employees from discrimination, harassment, bullying, uh, forcing employees to share personal social media is illegal in some states. We'll get into that. If you're forcing an employee to share anything really personal, you could be violating a right to privacy where it is in the Constitution in that state. That could be anything protected class related or reason for needing leave if they're seeking a replacement. That could be an invasion of privacy. Asking employees to share anything with family or friends, asking to retweet a promotion from your employee group could also be an invasion of privacy. Your private Facebook or Instagram for your employees is never truly private. The internet is forever. Again, you can't stop one employee from opening it up and showing the world something that an employee would have thought they would only be seen by their coworkers. So asking employees to share anything on a work Facebook group could be an invitation to an invasion of privacy claim. And social media privacy laws, like I mentioned, most states have laws requiring, preventing you from requiring an employee to provide a social media password, prohibiting you from requiring an employee to friend you or accept you as a follower or a connection. Some laws prevent shoulder surfing, prohibiting you from having the employee to log on to a personal account in front of you. And this is a big reason of this is because employees might want you to know something about their sexual orientation, something to know about their familial status, something intensely private, such as a member of an infertility or child loss group. And or some, are you going to fire someone because you saw their social media and saw that they're getting married and you're worried that they're going to spend more time planning their wedding than doing their job? Medical disability information is a hot potato. You shouldn't have it if it's not job related and consistent with business necessity. And if you've got it on hand, you can actually be violating the Americans with Disabilities Act. So do not ask an employee to friend you or try to get an employee to accept you as a follower or connection on social media. So 26 states have some social media privacy law, but the definition of social media account varies by state law. The definition in the state of Nevada, for example, is you know, 2 paragraphs long, uh, and you can't ask to see or be granted access to or look over an employee's shoulder for any of that unless it is already public. So if an employee puts out a podcast on iTunes, you can listen. If your employee has to give out a password to log in and hear it, you can't require that employee to give you the password, even if the title of the podcast is What Sucks About My Job at Employer Name. We'll talk about harming your business shortly, but you can't demand to read a blog or listen to a podcast, even if you think it happens to be relevant to you and your business. This can include a Gmail account. You still can do key tracking, and if you let employees know they have no expectation of privacy in using your internet or computer systems at all, but you can't log into employees' Gmail accounts without letting them know. If an employee makes a Facebook page and sets it to private, and friends and coworkers look at it and they refuse to show it to you or let you join, you cannot do anything adverse to the employee, even if you think the Facebook group is how to scam paid sick leave. You can certainly punish an employee for scamming paid sick leave if you have reasonable objective evidence that you did it, but not because all the employees are on that group and they won't let you in. Legal off-duty conduct laws. In states that allow legal off-duty conduct, posting on social media is a legal thing to do when they are off-duty, and you can't take adverse employment if they're posting things you don't like. If you have an employer-run Facebook page, you can set limits what can be in the photos or what can be talked about. If you have employees, if you're in a legal off-duty conduct state and employees who have personal pages, you cannot do anything about what's on their page within certain guidelines. So you can't fire or take adverse action for them drinking, smoking a pot leaf or 420 political candidate or party pictures at a rally or a campaign event. However, as I said, it is legal off-duty conduct. So political activity must be lawful. If someone posts themselves at a peaceful Black Lives Matter protest, that is protected from you taking action against them. If someone posts a picture of themselves at the January 6th insurrection, breaking a window, that is not protected activity. So even if they're both protected activity and you may have hot opinions on both of those issues, one is protected and you can't fire the employee for one of them, but you can fire the employee for the other one because the key word in that is lawful, and you can't fire the employee for lawful off-duty conduct. But if their behavior on their social media, if they're carrying firearms that they're not allowed to be in possession of, something like that, using illegal drugs on their Facebook page, that is not legal off-duty conduct. And then you can do that. Making rules about what can be on the work Facebook page is not discrimination. If it's a work Facebook page, you can set the standards about what is on that, even if technically they're posting when they're off the clock. you set the guidelines for what occurs on your work Facebook page. Um, like I said, illegal off-duty conduct on Facebook can be grounds to cut an employee loose. However, do not be racist. Do not assume someone is a drug dealer or a gang member because of certain things or friends on their page. But pictures of an actual crime, you can hold it against them. Freedom of speech, the First Amendment is saying that the government cannot make laws punishing people for what they say. They're not saying that you, a private party, can't make a rule restricting people's speech. So the Constitution protects us from the government because we're all essentially helpless to laws that are made. The Constitution doesn't protect your employees from what you necessarily say because your employees can always go get a different job. So you can restrict your employees from saying things that are discriminating or harassing based on a protected class or sexual harassment. You can certainly protect your employees from saying something like that and discipline for that type of speech. So freedom to say whatever you want at your job, whether out loud, online, a t-shirt, any other way is not legally guaranteed. 13 states have extended the constitutional rules to private employers, not just the government. Generally, in those 13 states, employers cannot restrict speech about a matter of public concern or social justice, and there is no freedom of speech when the speech interferes with the employee's job performance or relationship with the employer, or it disrupts working time and operations. So public concerns means in these states you can't necessarily fire your employee for making a statement about abortion, even unless it disrupts working time and operations. If this causes a huge if everybody stops doing their job and joins in the conversation and nobody's working because everybody's yelling, that disrupts working time and operations. And even though the 13 states have extended the free speech protection to private employers, if it disrupts your working time and operations, you do not have to allow it. You do not have to allow something so controversial on social media that it disrupts your employees to work together. If no one can get any work done, management can take it down from social media. If it's on a personal page, you have less ability to restrict their freedom of speech. You know, if it's something like a COVID denier and they're spreading medical misinformation, this doesn't really apply so much anymore. I don't know, is it harmful? Is it a political opinion? It is kind of a gray area on your group work Facebook page. Some other speech is specifically protected by other state laws. The National Labor Relations Act and social media in 2023. The NLRB is currently leaning left. You could see some of the current rulings on social media pulled out from under you and flipped back around. This is not the Constitution. It is not written in stone. This is why you update your handbook every year. You may be able to prohibit something under one makeup of the board, but the board may issue a ruling that may make it so that you have to require employees to be explicitly allowed under another iteration of the board. So the NLRB is something you have to watch very carefully when it comes to social media. You still can't tell people they can't talk about your own wages. You can tell them they can't talk about other people's wages or client info or trade secrets, but not everything in your handbook is a trade secret. Employees can complain about your employee policies or benefits. Endorse, promote, or disparage means no employer sucks Facebook pages with your logo front and center, or using it to attract people to join our anti-employer group, or using your logo as a Twitter avatar on their account devoted to personal gripes. Still, you can not tell people that they can't wear their uniform to identify themselves as an employee if they are rounding up people for mutual aid. Tread lightly. This one could be touchy. You can have a no camera rule if your business interest outweighs the employee's interest. Um, no damage to goodwill or business or business income can be allowed, but if your employees were to organize a strike against you and publicize it on social media, that would be okay. That might make people think you have unfair labor practices, but employees would be permitted to organize a strike and put that on social media. And it looks like we're coming to the end of our time here. I would say when to intervene. Hate speech, an adult themed meme on a workbook, work Facebook page would definitely be a reason to intervene. Discriminating, don't tell a trans woman she can't have a bikini picture, but allow a cisgender man to have a Speedo picture. Probably don't let anyone have a bathing suit picture. But watch for those lawful off-duty conduct laws. Sexual harassment, cyber stalking, that's something to get involved with. Anything threatening, violence, bullying. Bullying is going to lead to high turnover. It's going to lead to illness. If you've got bullying by a large group against one employee, that's going to cause big problems for you. Discipline based on social media. If you've got employees taking leave under what you believe is the Friday, Monday Leave Act, be so careful with this. You can't require an employee to accept you as a friend. You shouldn't do the underhanded route of having another employee friend them and forward all their posts to you. If you are in a state where you suspect FMLA abuse, you should use other ways to investigate this abuse, workers' comp abuse. You should do this other than stalking on Facebook and trying to get into social media when the employee has refused you access. And there are ways for the employee to get around this as well. And so that's in conclusion, don't lean on an employee for a friend request if you're in a state that prohibits it. Don't exclude social employees who may not use social media. Hate speech and sexual harassment, anything that would violate your policies if the employees were working together should violate your policies on social media. Right now, you're pretty safe making policies that social media and blogging must be civil and respectful. And cannot denigrate the employer, but look out, some of the things that you are okay prohibiting right now could be switched by the National Labor Relations Board, and that could change. So I'm sorry I ran you over time here. Like Dan said, you will get a copy of the recording and a copy of the slide deck tomorrow to get more information if there was something I glossed over that you missed. But thank you all for participating in the webinar today. If you have any questions, please open a ticket in our Ask an Attorney portal. Or if you are not a client, please email us at info@myhrcounsel.com, and we would be happy to talk to you about our packages and how you can sign up and get answers to these and other questions. So thank you all, and I hope you all enjoy the rest of your day.
Thanks, Britt. I just wanted to add that social media policies are included in our Ask HR subscriptions. So if you are a current client of ours, we'd be happy to draft you an updated policy for your workplace. In addition, it's very important to update your employee handbook. That's also included in our Ask HR and Ask Pro service as well. And if you'd like to learn more, please email us at info@myHRcounsel.com today, or open a ticket and we can get you started on that new policy. Thanks again, and we look forward to seeing you again next week.